For those of you who don't know us, we are DLA Piper. We've been DLA Piper for a year now, a year and 4 days. So, prior to that, we were Davis, and before that, Davis and Company. We grew out in Vancouver, and we had a long history with the Japanese business community. As Davis is definitely the only company to continue as DLA Piper. As Davis, we were a national firm, operating over 250 lawyers across the country. As DLA Piper, we are now an international law firm with offices in over 30 countries, over 80 offices across 30 countries, with about 4,400 lawyers around the globe. So our takeover of this international organization is fun. Yeah. So I'm very pleased to have Brian here talking today. Brian's been my immigration lawyer for a number of years, and I'm still in touch with him. A lot of confidence. Brian recognized immigration lawyer, recognized by Lexpert, by Mark Hubble, who was best lawyers in Canada, and is a published author, written 2 chapters in immigration texts, our immigration group, and just an all-around nice guy. So Brian,
thank you, Mike. Thanks, sir. Okay, so as most of you know, there's been a lot of changes in immigration law in the last little while, in the last couple of years. So we're going to go over some of the recent changes and how they're going to affect you dealing with your staff, transferring them in, dealing with staff that you want to have become permanent residents, and then also how you as the employer can protect yourself, because now there are a lot more penalties, a lot more investigations, and a lot more inspections of employers. So we can get started. So the topics that we're going to talk about today is the new electronic travel authorization rules that came into effect March 2016, the new employer compliance rules that came into effect as of December 1st, 2015, the new email submission filing requirement of terms of offer of employment that have been implemented, the intercompany transferee work permit category update, including the expanded guidelines for intercompany transferee specialized knowledge work permits, definition of specialized knowledge, mandatory wage floor, talk about how Canada has split its temporary foreign worker program into 2 streams. The changes to the temporary foreign worker program include new requirements for employers, the LMIA fees and the processing times, the stronger enforcement against employers that the government is now doing, enforcement, administrative monetary penalties, bans, blacklists. The government has really increased the amount of enforcement and regulation, and then significant changes to Canadian permanent resident application procedures and changes to the Ontario Provincial Immigration Program. So I was talking to one of you before this talk today, and they were just talking about Canadian permanent resident situation, and they were saying that it's changed so much, and I was explaining beforehand how it's changed so much. And if you want to have some of your staff become Canadian permanent residents, you really have to take a close look at what the new changes are, because there's been a lot of them. Okay, so let's talk about the electronic travel authorization. On March 10, 2016, it was announced that from March 15th, visa-exempt foreign nationals who fly or transit through Canada will need an electronic travel authorization. I'll just start calling them ETAs. It's also been announced that from March 15th until the autumn or fall of this year, travelers who don't have an ETA can still board their planes if they have a passport. So some exceptions that do not require an ETA include U.S. citizens and travelers with a valid visa, including a work permit. So the process of applying for an ETA is very simple. You go through Immigration, Refugees and Citizenship Canada. Prior to this, they were called Citizenship and Immigration Canada, but with the new government, they've changed some of the names, so this is what they call Citizenship and Immigration Canada now. So whenever I refer to IRCC, just think the old Citizenship and Immigration Canada. So in my paper, there's a number of links that you can go to, and they'll give you a step-by-step guide from IRCC about how you can get the EPA. It's really not something that you need a lawyer for. It's very simple. It's very straightforward. You'll need to pay $7 by a credit card. You won't get any printout or any confirmation of getting an EPA. It's linked to your passport electronically, and it's valid for 5 years. You can apply for the EPA at the website there. There's some useful information on the other link, I should say. This link talks about what is EPA. The next link, you can find out if you need to apply for EPA. And then finally, how do you fill in the EPA form? It's in that link there. So I'm now going to talk about new employer compliance rules that came in as of December 1st, 2015, and the consequences for employers that break the rules. So on July 6, 2015, the government announced stronger consequences for employers who violate conditions of the Temporary Foreign Worker Program, or the International Mobility Program. These changes are designed to promote compliance and deter employers from misusing the programs and mistreating foreign workers. So they provide proportionate responses to non-compliance. They've increased the previous 2-year ban, so now you can get bans from a ban. When I talk about ban, if you violated some of the provisions, then you could be banned from having any foreign workers for a period of time. It used to be 2 years, but now it could be 1 year, 2 years, 5 years, 10 years, or even forever. So they've really increased how much more the penalties will be. They can also give you a warning, and there can be financial penalties. So now, your financial penalties can range anywhere from $500 up to a maximum of $100,000 per violation. So what this means, if you have 10 employees that are all doing the same violation, theoretically, that employer could be fined $1 million. So it's up to maximum fine of $1 million in a year. So these changes came into force on December 1, 2015, and they'll apply to any violations that occurred after that date. For any compliance violations that occurred before December 1, you will be held to the penalties that existed previous to December 1, 2015, and that would be, for example, a 2-year ban rather than these other lengths of ban that are available. So an employer that's undergoing an inspection under the new rules, they need to be aware of the following changes. So there are new consequences for violations. So there could be warnings, there could be the fines that we've talked about, the bans that we've talked about, and also there could be a publication of the employer's name on a public list with details of the violations and sanctions. So this is a blacklist. And also there's a new method of assessing the consequences of non-compliance. So they've now created a point system. Before there was no point system. It was either you violated or you didn't. Now they have a point system, and the points they calculated based on a number of different categories. So the type of violations, an employer's compliance history, the severity of the non-compliance, and the size of the employer's business. So if they're going to hit you with a fine, a bigger company could be subject to more of a fine, is what they're saying. They also have a new provision, which employers can come forward and voluntarily, I'm going to call it, confess, they call it disclosed non-compliance. I'm saying you confess that you've made some violations, and potentially you can receive a reduced consequence where applicable, so a reduced penalty. Nobody knows what this means, of course, because this is new and nobody's come forward and said we're guilty, and then find out what government will do. So I would recommend that you don't run forward and start confessing that you're guilty until we find out how the government is going to treat companies that confess they're guilty. A new formal opportunity is now available for employers. If they don't like the preliminary finding, then they can ask that their case is reviewed by a different officer. So that wasn't there before. So there's now a new email submission filing requirement of the terms of your offer of employment. So there's a new method that you use to submit it. So as of October 26, 2015, all employers under the International Mobility Program, so those are work permits such as an intercompany transferee that don't require a labor market impact assessment, need to submit an offer of employment form and the employer compliance fee. And as of December 1, 2015, they've now changed it again. So now, when you submit the employer compliance fee and you submit the information, you don't use the form anymore. You create an employer portal, and then you put the information into the employer portal and you pay the $230 compliance fee into this employer portal that you create. And so we can, for example, for most of our clients, they ask us to create the employer portal, and we do. And when you're doing that, there's an initial stage where you put some preliminary information in, and you give the contact person at the company, and then the email goes from the government to the contact person at the company and says, okay, you've done this first part, the preliminary part, and then we always ask our clients to send us that email, because then we know we can go on to part 2, and then we create it. So it's more of a headache than before. 2 years ago, you didn't have to provide any of this stuff. On October 26th, you could at least fill out a form, and then the guy and then submit it. And now it's totally, there's no form. You have to go and create this employer portal and put it into the portal. As I've just talked about, more detailed information is required from the employer portal. And then this information must be inputted. You need to set up the employer portal, put the information in, pay the $230 compliance fee, and you need to have proof of that. And when your person goes to the port of entry, so if they fly into Vancouver Airport or Toronto Airport and they apply for their work permit, they need to have the proof that they've set up the employer portal and paid the $230 and inputted all the information on the offer of employment. And if they haven't done that, they don't prove it to the immigration officer at the port of entry, they won't accept your work permit application. So you need to have this done first before your person shows up at the port of entry, when they fly in or they drive in, and also when you do a work permit extension. So if you want to file the work permit extension at Vegreville, you need to have done what I just talked about first and have the receipts and the proof, and you put that in with your work permit extension application and then file it at Vegreville. If you file at Vegreville before you've done that and you don't include that information, they'll reject your application. So we've actually had some clients that came to us after they did it on their own and said, please fix it, so I can fix it. So now there's expanded guidelines for the intercompany transferee work permit with specialized knowledge. So there's a number of pages here that go into great detail about what does this mean. I'm going to just condense it down to basically 2 points. So on June 9, 2014, the government provided guidelines saying we need to have more information if you're going to have your person apply under intercompany transferee specialized knowledge category. And what they want is your person now has to show that they have specialized knowledge about the company and how the company does business and the company's products and services. That's number one. And then they also have to show they have specialized technical knowledge about what it is that that you're claiming they have specialized knowledge in. So for example, you could have someone that's being transferred from head office to here, and they might have experience doing joint ventures overseas in a certain industry, and they might have experience about how their company does international joint ventures. And then because that person has this experience doing these kinds of international joint ventures, they would have technical knowledge about how do you work within an international joint venture. So how does that particular company do their joint ventures? And then technically in this kind of industry, suppose it's a resource industry, oil and gas or mining, how do they do the kinds of specialized things that they do? Or you could have someone that's more of a service person. Like we've had people that are working in accounting departments being transferred from Japanese head office to Canada. And you wonder, well, how can you have specialized knowledge in accounting? Well, you can if you're used to doing certain kinds of projects. And then if you've got, then that gives you your technical special knowledge because you know how to do these kinds of projects because you've been doing them. And in particular, you might be in head office handling all the financial accounting and reporting for the project in Canada already. And so then you also have knowledge because you've been working for that company for a couple of years about how they handle their accounting in these kinds of projects. So those are examples of how you can meet this part of the test for specialized knowledge, which is now more difficult than before. So I'm just flipping through the specialized knowledge slides. So you've got the paper so you can read about it afterwards. And then the other thing that's changed is they now want to make sure that the salary that the person is being paid is high enough that it reflects that the person has specialized knowledge. So if the person is an accountant, if the person is an engineer, you need to look at what is the median salary for the accountant or the engineer and then pay more than that, right? So you can't be just paying what the average, the median engineer or the median accountant earns. You need to have that amount plus some more because you're arguing that your person is really specialized. And so you have to make sure that you've added that extra amount in to take care of that requirement. So we talked about how they've now split the temporary foreign worker program into, we're talking about how they split it into two streams. One stream is a stream where it's now called just a temporary foreign worker program, where people require a labor market impact assessment. They used to be called labor market opinions. And this is managed by Employment Social Development Canada. I refer to it as Service Canada a lot because that's what it used to be called, and it's still called in certain aspects. The International Mobility Program, this is the kinds of work permits that don't require an LMIA, and the kinds that you people would be most interested in are the intercompany transferees, because most of the Japanese staff that come to Canada on work permits, 90% of them are intercompany transferees. This is Citizenship and Immigration Canada will continue to manage this. So I'll talk about these changes in more detail, and unless I state otherwise, you can assume these were effective in June 2014. So the LMO has been replaced by the LMIA, which is more rigorous. It's more challenging to obtain one of these. So the LMIA requires the employers to provide information on the number of Canadians that apply for a particular job, the number of Canadians the employer interviewed, and an explanation if the Canadian applicants were not hired. the employers have to attest that they're aware that Canadians cannot be laid off or have their hours reduced at a work site that employs foreign workers, so it's protecting Canadians. So if you're hiring a high-wage temporary foreign worker, in almost every case you're going to have to submit a transition plan. So the transition plan, what the government is doing is they want to see that if this person, you've given a job to a non-Canadian, how you're going to work to give that job to a Canadian in the future. So the simplest way is to turn a non-Canadian into a Canadian. So that's one way that you can put in your transition plan, that you're working towards transitioning this job to a Canadian. And if you don't do that, then you have to provide all sorts of other special ways that you're trying to assist in this job being transitioned to a Canadian. So what that means is you need to show things like advertising in other websites, for example, Aboriginal websites, handicap websites, older person websites, younger person websites, and you have it, and you need to be offering things like relocation costs or other special kinds of things that you think the government thinks will help to induce Canadians to apply for the position. Transition plan is 10 pages long, so it can be a headache to complete. So when you're trying to determine what's high wage and what's low wage, before they used to do it by just looking at the National Occupation Code classifications, so certain jobs have, for example, would be NOC O, which is management, NOC A and D, which are technical skills. But now they've decided they're going to look at wages. So they'll look at the provincial median wage, and if you're above that wage per hour, you're high skill. If you're below it, you're low skill. So this is different from the way it used to be done before. If you have 10 or more employees, you can only have a cap of 10% of them that are low skill. And it's not applied on the whole, they don't just look at the whole company and say how many low skill people do you have. They look at each work site, so they would look at each office. So if you're a Japanese office and company and you had offices in Vancouver, Toronto, Montreal, they would look at each office separately. So to provide employers that are above the 10% cap, there's a transition period right now and it's going to be phased in. So they'll provide more details about how they're going to phase it in. So if you have people in the lowest wage, lowest skill, entry-level positions in any area of the country where there's 6% unemployment, they won't be granted. Low-wage temporary foreign workers, LMIAs, are only for a one-year period. You can apply for an extension, but extension will only be for 1 year. So to reinforce the temporary nature of the temporary foreign worker program, the cumulative period, so the cumulative cap of all your extensions will be reduced. So this one is one that can be troubling, is the LMI fee is increased to $1,000. So previously it was $275, and then a couple of years ago it was free. So this is troubling to some of the employers. So the Service Canada said, we're going to give processing time, we'll give special processing times that will be shortened to approximately 10 business days for certain categories. So in-demand occupations such as skilled trades, highly paid occupations, top 10%, and short duration applications, 120 days or less. The immigration lawyers across Canada, we talk about this, and so far there are fewer if any cases have been processed in 10 business days. So it's something that they wrote down that it's an option, but so far they're not exercising it very much, if at all. So the processing time for a regular LMIA application across Canada is approximately 8 to 12 weeks. The next category, stronger enforcement. So the number of inspections are going to increase dramatically, as will the number of program requirements that can be inspected. So they expect that 1 in 4 businesses employing temporary foreign workers will be inspected each year. So because immigration is federal, I deal with immigration clients for our firm across the country. So we've had to advise clients that are being audited or having inspections in BC, Alberta, and Ontario. And they're time consuming and they're not pleasant. And we've had one client that's been audited for more than a year. And it just keeps going on and on and on. So enforcement, administrative, monetary penalty regime, bans, and blacklists. So CIC can use any discrepancy in your job offer against the employer. So it's important for the employer to be very careful when creating or confirming the contents of your job offer prior to it being submitted to CIC. It's also important that the employer continue to comply with the information submitted in the job offer for the full term of the employee working for the employer. So in some of these audits, we've had people that complied at the start, and then their accounting, their bookkeeping got sloppy, and they weren't complying. And when they got audited by the government said, "Well, you're okay here, but you didn't continue, and here this is a problem." So a lot of times, the best when you're being, if you get audited, and if they find that there are discrepancies. So for example, some of the discrepancies they can find. We've had situations where people, the amount advertised for the position was 2 or 3, 5 cents higher, and when they paid them, they were off by that amount, and the government said, "Look, this is a problem, you need to fix this." So, and we've had situations where employers didn't calculate overtime correctly. Or we've had situations where employers didn't, they had people doing the same jobs in different locations that were being paid different amounts, and they should have been paid the same. So all these sorts of things are things that your admin staff needs to be very careful about, because if not, and you get audited, then each one of these is a violation. And this is before all these really harsh penalties came in. The way that we found is it's like when you're having a court case with another litigator over a commercial matter, you settle. So you basically, how much was this staff underpaid by? You calculate it, the government, and you talk about it, and then you just pay the staff the amount that they should have been paid, except for the employer's mistake. But it's a hassle, and as I said, we have one client that's been on. They've continued to audit and audit and audit. It's gone on for a year. So I'm not the only lawyer that's advising them. They have another lawyer advising them, and they're just racking up huge legal fees. And it's over administrative small things like I just described to you, except they've got a bunch of them. And they've got a government investigator that just won't let go, because usually we had one investigation where there was a number of things that they were concerned about, and we said, look, if there's 5 things, we'll settle on 3 of them, and then they said, fine, we'll take the other 2 off the table. But in the case that we've had that's going on for a year, they won't let up. They just keep going on and on and on. And if you're the HR admin person, your president's not going to be happy if this is ongoing, because while this is ongoing, you cannot go out and get any new work permits. So that's the stick that they have. You can't get an LMIA, you can't get a work permit. You have to transfer new staffing from Japan, you can't do it. So that's why, another reason why you need to settle these things as soon as you can. So the requirement, so I talked to you about how there's a new system where you set up the employer portal and you pay the $230 CIC filing fee. So this is a significant development because these fees that they're using, that they're collecting, they're using this to offset the cost of hiring more people to go out and do these investigations. And then of course when they do the investigations, they find mistakes and they get the employers to pay fines or pay the penalties or whatever. So this is how the government's funding more inspections and more, just more of everything of this compliance. So what are some of the excuses that you can use as the employer to get out of when you get audited? So previously, the employer could use the justification that non-compliance was due to bad faith, errors, unintentional accounting, or administrative errors. These justifications were used by employers when they're being fined or banned, and they, in some cases, were successful. This is no longer the case. These justifications are no longer valid as a defense to fines, bans, and blacklists. So there's only certain justifications, so certain excuses that you can still use as defense if you're being investigated. One is force majeure, which is basically force of nature, changes to federal provincial laws, collective agreements if you have unions, and economic conditions. What does economic conditions mean? We don't know. Okay, so now we're on to significant changes to the Canadian permanent residence PR application procedures. These started in January 1, 2015. Canadian permanent resident application procedures for the skilled worker categories changed dramatically on January 1, 2015. Under the previous procedures, if an applicant filed a Canadian PR application in one of the previously existing categories, if you qualified, you filed it, and you just waited, and then eventually you got your Canadian permanent resident status. So it was slow, but it was predictable. And then in Canada, each province has its own provincial immigration program. They call it the provincial nominee program, so all the territories have them as well. Previously, the general processing times were federal skilled worker was 22 to 24 months. Canadian experience class was 12 to 13 months. Federal skilled trades, there's no processing times available as the program is new. And PMP was 18 to 22 months. So now, on January 1st, 2015, the new federal system was introduced, and it's called Express Entry. So under the Express Entry system, a candidate that's interested in coming to Canada has to submit an Express Entry form online. So you need to meet the eligibility criteria for at least one of the federal programs. Federal Skilled Worker, which is a points test. Canadian Experience Class, which is the simplest one to meet. You work for a year in a skilled program, have a certain English IELTS score, and you pass. Or Federal Skilled Trades. Or a portion of the PMP. So if you get approval from a PMP program, that will help you in your point total when you enter all your data into the Express Entry pool. So basically you set up a profile for yourself and you enter all the data about yourself, and then you're given a points total. And then every month the government publishes, the government looks at all the applicants, and they pick a number for the point total, and anyone that's above that number gets invited to apply. If you're below it, you don't get invited. So their goal is, if you get invited, that you will get processed in 6 months. An Express Entry submission is not a guarantee of receiving an IPA. the way I described it to you, you could put in your profile, and if you never get above that, the monthly score, you're never going to be invited. And then the other thing is that these profiles are only good for 1 year. After a year, they disintegrate. So then you have to enter a new profile. So the immigration lawyers have compared the new express entry system to a dating site for immigration applicants. So it's like Lavalife or Match.com or eHarmony. And the reason is, when you put your profile up on any of these dating sites, unless someone likes you, you don't get a date out of it. And so under the government system, unless the government likes you, they don't invite you to apply, which is like a date. So under the express entry system, CIC will be reviewing a number of factors that they think will make the applicant more attractive, such as the applicant having received preliminary approval under Federal Skilled Worker, CEC, Federal Skilled Trades or PMP, a work permit, or an LMIA. So there's continually going to be new applicants entering the site. So if you want to continue to remain attractive, you need to continue to update your express entry profile. So how would you update your profile? Well, if you wrote the English test again, you got a higher score, you could put that in. If you got a new, if you got a new LMIA that you didn't, suppose you were here on express entry before, sorry, on intercompany transferee, and then you applied for an LMIA, and it sounds strange, but you can apply for an LMIA even though you're here on a work permit. And Service Canada understands that you're doing that because you want to apply for permanent status. So they realize it's not really an LMIA for a job, it's just to get the points, to get the permanent status. Or you could be here on a work permit as an intercompany transferee, apply to PMP, get the preliminary approval from PMP, and then put that into the website. If you get an LMIA or if you get a PMP approval, that's worth 600 points, and generally that alone is enough to get you an invitation to apply. So it's also mandatory that the applicant have taken an English test, such as an IELTS or a French test, to be eligible to apply for express entry. So I just talked about why it would be useful to get an LMIA or a PMP approval, because with those extra points, it makes your profile on express entry more attractive because your point totals have just had a significant increase in number. And this increases the likelihood that you'll be invited to apply for permanent status by the government. And it's a pretty clear process, because when the monthly number comes out, if your profile's below that, you know that you're not going to be invited. So in general, the new express entry system is not as predictable as the previous system. There's far more uncertainty considering whether you'll qualify for Canadian PR status. It's now been in effect for over a year, so we should be expecting more announcements as they refine what's going on. They're finding they're having some technical difficulties, because before it was paper, now this is all online. So even something as simple as inputting your work experience, when it's on paper, you can see it's from this month to this month, or from this date to this date. Well, under this new system, it's not as clear, and so people are finding they might have 11 months in 5 days, and the system just rounds it up to 12 months. And this is a problem, because under the express entry system, when you input your data, you don't have to provide the backup for it, for example, for your work experience. But when they invite you to apply, then you need to provide all the proof of all these things. And when they invite you to apply and you don't have the proof, then you're banned. So some people are inputting their data, and they might have 11 and a half months, and then the number comes out for that month, and the government invites you to apply. If they accept the invitation, then they won't have the documents showing that they have the, for example, the 1 year experience to make to qualify their Canadian experience class. And if they don't have the documents, then they're banned after that. So what happens is that you have, if the government invites you to apply, you don't have to accept the invitation. You can say no. So you could say no and pass on it, and then another month or 2 months go by, and then you do have the actual 12 months you need. It's not just 11 months and 5 days. So that's how you would deal with that situation. And that's happening now. I was just at a national conference, and the government official that was responsible for Express Entry was going over some of the technical difficulties that they're having right now that they're trying to fix. Like this is computer stuff. They're trying to fix it, and they're working on the software, but so far there's no fix. All right, so changes to Ontario PMP. So there's been changes to provincial nominee programs across the country. I write 2 chapters in 2 immigration books for lawyers. One chapter is about only British Columbia PMP. The other chapter is about all the PMPs across the country. So of all the stuff I'm talking about, this is the stuff that I'm best known for. I'm a national expert on PMPs. I write 2 books. So we're in Ontario, we're going to talk about Ontario PMP. A lot of the changes are similar. Next week I'll be speaking to the Komakai in Vancouver on Wednesday. On Thursday I'll be speaking to the Alberta Japanese Business Association. And on all these provinces, my last part will be about the PMP. So the PMPs are different in most of the provinces, but there are things that are similar. So in Ontario, your PMP has also created an express entry program. So in order to be eligible for the Ontario PMP Express Entry Program, you must first have registered under the Federal Express Entry Program. So after you receive your Federal Express Entry Program profile opening number, you can then take that number and register under Ontario PMP under the Express Entry profile. So same as Federal Express Entry, it should be noted that the applicant needs to take an English or French exam and obtain a certain score in order to create a Federal Express Entry profile. And if you don't get that, then you can't come back and create your Ontario Express Entry profile. So one of the first things that I advise people is go out and write your language test so you at least know what your score is. Some other changes to Ontario PMP. We've got 2 new streams for skilled workers, human capital priority stream. There's a French-speaking skilled worker stream. Ontario PMP searches express entry pool and identifies possible candidates. And they want candidates who have a minimum of 400 points on the comprehensive ranking system and meet the criteria of Ontario's human capital property system. So go back there, if you just search Ontario PMP or go to the Ontario government website, you can go and read all about all these changes. There's a lot of changes. I've just done a couple slides on it. This just gives you an overview of what you need to look at. So how do you keep up with the changes that are happening all the time? Nowadays, everything is on the internet, so you need to go to the government websites and regularly review them. There's the Citizenship and Immigration Canada website, the Service Canada website, the Canada Border Services Agency website. If you want to look up Ontario PMP, you go to the Ontario PMP website. And then some of the changes are not just on the website, some of them are practice changes or policy changes, and they don't necessarily appear on websites. So you can go and look all that up, or you can call me at the LA Piper, and my phone number is on the next slide. Thank you. So any questions? Yes?
So, the electronic travel authorization, will a new intra-company transferee who's coming in to apply for work permit be required to have an ETA as well?
It will depend what the nationality is.
Is it from a visa exempt country?
I will need to check on that. Okay. Yes.
So should they audit or investigate if you happen to get chosen and selected to be investigated? Will they only investigate the one offer, or will they investigate all existing intra-company transfers?
Well, once they come in for one, they can start digging. Okay, so the audits that we've seen, usually it's one thing that triggers it. But once they're there, they can start digging through all your records. Right, so they don't know, for example, one of the clients had 5, let's do an example of 5. They didn't know there was 5 things, they just had a suspicion of 1. But as soon as they get in, they start to dig. And then the one client we have where this has been going on for a year, they didn't think there's a year's worth of stuff to go through, but they just keep digging. And so this, I wasn't involved at the start. The client was having problems. They thought they needed additional assistance, so then they brought me in. But the auditing already been going on for 9 months. So I've been involved for the last 3, and we're just trying to settle everything. So they had other lawyers, but they wanted additional assistance. So it's a big headache for them. Yes?
So on the same note, you had to mention that the contents of the job offer is very important when they audit you. So what when the transferee is here for example, a 3-year period, and partway through their term, they get a promotion to a new job title or a new salary. In that case, then they have to change the work permit to match the new job title?
Yeah, so this is a question we get asked all the time. So if it's, the safest answer is yes, you should apply for an adjusted work permit. The practical answer is sometimes you call Service Canada or call Immigration Canada and say this is what the situation is, and they'll say, oh, you don't need it, so the salary increase is so small, and somebody gets 10 cents more an hour, they don't care. But if somebody gets promoted from senior manager to senior vice president and their salary goes up $100,000 a year, then you need to file an application to amend your work permit because it's clear that there's been a substantial change in title and in salary. And I threw out 100,000, but I've actually had someone that got that kind of promotion. It was 80,000. So we did file a change for a new work permit to reflect his new position.
Thank you for your presentation and explanations. I have a question about transitions from a temporary foreign worker. You talked on page 9 about the transition plan.
Yes.
How forcefully is this, what is it, required of an employer? For example, you get the what is it, NNIA for one cycle, and then you try to hire for another cycle. Of course, I guess the authorities would go back to the transition plan that you had submitted beforehand for the first cycle. But how is that enforced?
So what happens is you say, this is our transition plan, this is what we choose, what we're going to do. And you say we're going to transition, for example, let's use the permanent resident, because we've had this on a couple of cases. So you say we're going to assist this guy to become a permanent resident. So then, let's say it's only for a 1-year period, and then then you're going back, and we actually had this situation. And so we explain, he's applying for PR status, here's proof that he's applying. And we're granted a second LMIA. So they're satisfied because he's applying. It doesn't happen overnight. But you show the Service Canada that he is applying and you are assisting him, and that's fine. And similarly, if you say we're gonna suppose you don't do the permanent resident thing, but suppose you say we're gonna advertise in other websites, and you say Aboriginal website or handicap website or whatever the website is, they're gonna, and suppose it's a 1-year LMIA, and then you come to the second year, they're gonna want to see copies of those ads. We've had this situation occur as well, and so you keep advertising and then provide them with the ads to show that if you promise it in the transition plan and you don't do it, then that's a problem for the employer.
Thank you.
Yes?
So IMP and the ICT are different scheme, right?
Mm-hmm.
So if so, if a company hires foreigner only through the intra-company transfer,
Yes.
then the employer does not need to apply to an employer pay compliance fee and also using the employment portal. Is it correct?
Okay, so your question is if your company is only using the intercompany transferee
Yes.
work permits. So if they're doing the intercompany transferee work permits, every time you get a new work permit, you still have to set up the employer portal and pay the 230 compliance fee. Every guy, every person.
Even though through ICT, you need to pay.
Yes. See the $230 compliance fee and the employer portal, that is the way that they want a record of what intercompany transferee employers have said that they would do for their employee. So then if they audit you, now they have your written statement saying, this is what we're going to give our employee. This is what the conditions are, this is where he works or she works. And if they audit it, they can just take that piece of paper and say, okay, let's look through your records and let's see if you're paying that person what you promised to pay them. That's what that's about. Any other questions? Ito-san, do you want to say anything? Or Mike, do you want to say anything?
Brian, I was just going to say thanks so much for doing this and to everybody for coming again. Thank you very much. I did also want to mention, shameless promotion. We have a labor and employment conference that we put on May 6th. It is for those of you who are interested in labor and employment issues, you're welcome to come to the Capital Business Square. Make sure you get an invite. It's just downstairs at the Board of Trade, and it covers all sorts of legal problems and problems, from how to deal with aging workers to new updates to occupational safety legislation, issues with independent contractors, and we have some colleagues across the country to address those topics. So anybody who would like to invite us to see Community Business Card, I'll make sure you get it.
The other thing is, it's free.
It's free. It's free, and it counts for CHRP credits if you're May 6th. That's right, May 6th. Thank you, everybody.
Okay, thank you very much for Brian. For informative session. Now for lecture part is over, but if you want to speak with Brian regarding for your kind of a special cases or personal cases, please, do you have a time?
Yes, I don't plan until Sunday.
So he has a time for maybe another half, 30 minutes. So if you want to speak to him, so of for the next game. Okay? Thank you very much for joining us. The next session will be maybe next session will be that in something in June. And so we are planning to have the kind of benefits, group benefits and talk with the company who deal with the border trade, the rate survey, with their help. So we will send the invitation to